Hi, Vinay sir. Am I audible?
Yes, hello, good morning. Yes, you are audible. Am I audible?
Yes, sir. You're audible. So shall we wait for 5 more minutes?
Yes, let us wait for 5-6 minutes and then start.
Yeah. Okay. Thank you. Hello, Vinay sir. Shall we start now?
Let us start.
Friends, we are starting today's session. This is our 8th day of National Tax Lecture Series. Welcome, Vinay Shraff sir. Welcome every participants. We can start, sir. Over to you.
Yeah, thank you very much. Good afternoon, participants. Today we are going to discuss the provisions relating to arrest and provisions. So before I start the discussion from the provision of the GST Act, I think it is very much essential for us to understand. As I was saying, that for us to enable to understand the provisions relating to arrest and prosecutions within the purview of the GST Act, I think it is very much essential that we understand some fundamental and basics of criminal jurisprudence in terms of CRPC. So that is criminal. So now let us understand some of the fundamentals of the CRPC relating to the arrest and prosecutions and bail and bailable offense and anticipatory bail and all that. So first of all, the offenses are classified into two types. The one is which are considered to be grave offenses are called cognizable offenses, cognizable and non-bailable offenses, and other offenses where which is not considered to be so grave are non-cognizable and bailable offenses. Now, non-cognizable offenses are those offenses where a person cannot be arrested without issue of arrest warrant by a competent authority. But the cognizable offenses are those offenses where the arrest can be made without issuing any arrest warrant. That is the first thing. Secondly, the bailable offenses are those offenses which are specified in first schedule to the CRPC. Now, CRPC first schedule is divided into two parts. First part deals with offenses under IPC and second part deals with offenses under any other laws. And non-bailable offenses are those offenses which are not included as a bailable offense in the first schedule. Now, as far as the GST law is concerned, the offenses are classified as bailable or non-bailable depending on the maximum amount of sentence. But before I go to the provisions of the GST, let us understand as to how it is structured in terms of the CRPC. Now, if the offense is a bailable one, then the CRPC says that the right to claim bail is absolute and indivisible, and as long as the person who is an accused and who may be arrested, he will have to be released on bail provided he is willing to provide the bail amount. Now, what is the bail amount? The bail amount is the amount which is fixed or the conditions which are fixed for not arresting. The conditions which are fixed may be a bond in terms of a money or cash security, or some conditions may be imposed. For example, the person may be required to present himself before the investigating authority at a particular interval, or he may be conditioned that he will not leave the city or the country, and if he if the condition is that he cannot leave the country, then his passport is also impounded. So there can be variety of conditions which can be, or for example, that he will not tamper with the evidence, or that he will not threaten the witnesses. So if any of these conditions are violated, and if the prosecuting authorities makes an allegation once the bail has been granted that the accused is not complying with the conditions of the bail, then the court is entitled to immediately cancel the bail, and that person, once the bail is cancelled, then he will be liable to arrest. But till such time he is complying with the conditions of the bail, he cannot be arrested. So that is point number one. But the non-bailable offense does not mean that the person cannot be granted bail at all. In fact, the jurisprudence is that the bail is the norm and the jail is an exception. Now we will discuss with the various landmark judgments within the purview of the CRPC with respect to the condition for arrest, or when the arrest should be made or should not be made at all. So one such judgment, which is a landmark judgment of the Honorable Supreme Court, was delivered in the case of which is called the judgment in the case of the Arnesh Kumar, wherein the Honorable Supreme Court laid down that as long as the person is willing to participate in any proceeding which is initiated against him, he should not be arrested. And if there is no threat of the concerned accused tampering with the evidence or not participating in the process of investigation, he should not be arrested at all. So it is not that if there is a offense is non-bailable, then the bail will not be granted. The only thing is that the concerned person should be presented before the magistrate, and it is only the magistrate who has the power to grant bail. But in case of a bailable offense, the arresting office or authority itself, for example, a police officer, or in the case of a offense under the purview of the GST Act, the concerned officer himself is empowered to grant bail subject to the condition of the bail which is imposed upon the accused. Now, there are some of the important provisions of the CRPC which are equally applicable to the GST also. So section 50 says that whenever a person is arrested without warrant, it is the duty of the police officer to communicate the full details of the offense for which the person is arrested. And also, if the offense for which the person is arrested is a bailable one, then it is the duty of the officer to inform that the person is entitled to be released on bail after giving the required surety. So it is the officer himself who should intimate the accused whether, if he is arrested at all, then whether the offense which he has committed is a bailable one or non-bailable one. So the accused need not know the law with respect to the nitty-gritties of the law, whether the offense is a bailable one or not. Only thing which is important for us as a professional is to understand, that we will discuss a bit later on, as to what are the classification of the offense which are bailable and non-cognizable, and the offenses which are cognizable and non-bailable. Now, in one of the very important judgment of the Honorable Supreme Court, it was held that the merely because arrest can be made, it is not that the arrest should be made. the court should be very careful before issuing non-bailable warrants. So, and it also said that the whole purpose is to make an investigation. So if the non-bailable warrants should only be issued when the summons are unlikely to have the desirable result. So similarly, in the case of the GST also, if by issuance of a summons under section 14, the desired results can be obtained and the person concerned, who is an accused, is not likely to run away or not cooperate in the investigation, only then the personal liberty of the accused should be interfered with. Otherwise, the law says that the deprivation of personal liberty of an individual is the most sacrosanct right, and it should not be interfered with reasonably. Okay, we have already received some query. We'll deal with it. Now somebody is saying unable to hear. Am I audible? Okay, thank you. Now, for a non-bailable offense, one has to, as I said, one has to move before the magistrate, and the magistrate sets out the grounds for granting of the bail. And usually in a bail petition, one should give a detail of one's bona fide about where one is residing, whether one is a permanent resident in a particular city where the investigation is going on, what are his assets, whether he is likely to flee if he has a permanent residence, and his background, so that it can help the magistrate to come to a conclusion whether what are the antecedents of the accused and what are the credentials. And those credentials are really very helpful to the court to come to a conclusion whether one is likely to tamper with or run away or not participate in the proceedings. Now, another judgment of the Honorable Supreme Court says that in the case, the court directs an under trial prisoner to be kept in custody, then the court should pass an order for conducting trial as expeditiously as possible. Now, the reality is that in real sense, a lot of under prisoner trial prisoners are languishing in the jail, and that expeditious hearing is an utopian dream only. But nevertheless, the Honorable Supreme Court says that if any under trial is kept in prison, then the least which the court should do is to ensure that there is a speedy trial and conclusion of the proceedings. Now, another jurisprudence with respect to bail is that if the bail is granted, but the conditions of the bail are such that it will be nearly impossible for the accused to comply with such harsh condition, then it would tantamount to denial of the bail only. And it would be like paying lip service to the cause of the bail. So the conditions should be such which the accused should ordinarily be able to comply with, so that the bail does not remain a distant dream and one should be able to exercise his right if the bail is so granted. Now, in a very recent Supreme Court judgment dated 20th of January 2023, the citation is given in this slide. Herein, the condition for the granting of the bail, wherein there was a dispute of the ITC fraud. So the bail was granted by the Honorable High Court, but at the same time, it set a condition to deposit rupees 70 lakh. Now, in this backdrop, it was argued that as of now, no assessment has been made. And since no assessment has been made, so the condition to pre-deposit such a huge amount is not possible. So Honorable Supreme Court set aside such a condition to deposit the 70 lakh rupees and granted the bail without depositing any money whatsoever. Now, another aspect of the bail is that the bail is such a right, the right to seek bail is such a right that one can repeatedly appraise the court. It is not that once the bail has been rejected, then you have to wait till the time of the custody granted by the court is over. Because usually courts at the initial stage grants a custody of 14 days. So it is not that one has to wait for those 14 days to be over for making a fresh bail application. If the condition so warrants that fresh bail application should be made or such conditions arises, then one can definitely approach the courts again and again. Now, another important concept with respect to jurisprudence of bail is that suppose somebody is arrested, but the investigation is not completed and charge sheet is not filed. Then in such a scenario, if the offense is punishable with death, imprisonment for life, or imprisonment for a term not less than 10 years, then once the 90 days expires and the investigation is not completed, then the right to seek bail is absolute and an indefeasible right of the accused, and the bail has to be granted by the court. In the case of GST, since the offense is less than 10 years, the maximum offense which is stipulated in the GST Act is 5 years only. So within a maximum period of 60 days, the GST authorities are supposed to complete the investigation and present a final investigation report before the court in order to seek custody of the accused. If that is not done, then the accused acquires an indefeasible and absolute right to be granted the default bail after expiry of 60 days of custody. Now, another section 436A of CRPC says that if more than half the term of the conviction is undergone by an under trial accused, then once the 50% of the period of conviction, maximum period of conviction, the bail should be granted. So if it is, say, 5 years in the case of GST, then after expiry of 2.5 years, even if the investigation report is filed, the bail has to be granted. Now, there is a another concept under the CRPC, which is anticipatory bail. Now, if one is apprehending arrest, then one can approach the court saying that, look, I am apprehending arrest, and if I participate in the proceeding, then it is highly likely that I will be arrested. So I am willing to participate and cooperate with whatever proceeding is going on against me, but the authorities be directed that till the time the investigation goes on, I should not be arrested. So anticipatory bail is generally made when one is apprehending arrest prior to arrest. So in the context of GST, for example, if someone is issued under Section 70 of the GST Act, and if the allegation is so grave that one feels that the arrest is going to happen, then one should necessarily approach the court with an anticipatory bail application. And if the court finds fit that the credential of the applicant are such that he is not going to tamper with the evidence, he is not going to threaten any of the witnesses, and he will cooperate the investigating authority in their investigation, then the court may grant anticipatory bail. Now, here also, if the conditions put for granting anticipatory bail are such that it is impossible to meet, then that is also likely to be set aside. For example, recently the Honorable Supreme Court in a very recent judgment, wherein the anticipatory bail was granted by the High Court, but at the same time, the court imposed a condition of the pre-deposit of the disputed amount of 14.68 crores. The offense was alleged to be availing of ITC on the basis of fake and false invoices. But the Honorable Supreme Court set aside the condition of the pre-deposit and allowed the anticipatory bail. Now, let us have a look at some of the procedural aspect of arrest, even though the procedural aspects are not defined in the law. Recently, the CBIC has come out with a detailed circular relating to the arrest. But before we go to the circular, let us have a look at one of the very celebrated and important judgment of the Honorable Supreme Court in the case of D.K. Basu versus State of West Bengal, which laid down the guidelines for arrest. Some of the important guidelines which was laid down was that while carrying out the arrest, the police personnel should bear accurate, visible and clear identification and name tags with their designation. The police carrying out arrest should prepare a memo of arrest, which should be attested by at least one witness who may either be a family member of the attestee or respectable person of the locality from where the arrest is made. And it shall also be countersigned by the arrestee and shall contain the time and date of arrest. So in the context of GST Act, if we see, if all these details are captured, then it will give a, it will help the assessee at the time of final trial or the assessment of under the tax, whereby say some on the basis of the arrest, some statement is taken, and from the circumstance it so appears that the arrest was made at a very odd hours, and it is highly likely that under the fear the statement which was taken was not voluntary, so it is going to help the arrestee. Now, another important guideline which was laid down was that the person who is arrested or kept in custody is entitled to be informed to a relative or a friend who can help him in getting the bail. Now, another important aspect is that as soon as the detention is made, he should be made aware of his right. And an entry must be made at the place of detention regarding the arrest of the person, which says also disclose the name of the next friend who has been informed about his arrest. And he should be medically examined within 48 hours during his detention. And the arrestee must be permitted to meet his lawyer during interrogation. So these are where some of the important guidelines laid down by the Honorable Supreme Court in D.K. Basu versus the state of West Bengal. Now, Honorable Gujarat High Court laid down some very important procedure for arrest, and wherein it was held that the arrest memo is a key safeguard against illegal arrest and harassment of the arrestee. So therefore, the concerned officer making arrest shall prepare a memo of arrest, and which should be attested by one witness. So, I mean, the kind of guidelines which is issued by the D.K. Basu versus the state of West Bengal, it was laid down in this particular Gujarat High Court judgment. Now, this judgment is in the context of GST. That is why I am citing it, and I think it is very useful. So it lays down almost all the guidelines which was laid down on the D.K. Basu versus the state of West Bengal with some additional additions. It was said that it is high time that the GST department prescribe the standardized format for arrest memo. The format should contain all necessary particulars and about the guideline. And the gist of offense alleged to be committed must be incorporated in the arrest memo. And it shall be the duty of the magistrate before whom because once the arrest has been made, then for seeking remand, whether it is police custody or judicial custody, the accused should be presented before the magistrate. Now, in a normal criminal matter, generally, if at the time of once the accused is presented before the court, then simultaneously a bail petition is also filed to oppose the remand or the detention. Now, in a normal criminal matter, generally, if the apprehension is that the court is not likely to grant bail, then simultaneously alternate prayer is made that the accused be kept in the judicial custody. Because judicial custody is always better than the police custody. Police custody is very, very difficult to deal with for an accused. The condition in the police, the jail of a police station is usually very, very cumbersome. So therefore, one usually tries to seek a judicial custody. In the case of the GST, usually the department itself, many times I have seen that they themselves seek judicial custody, but nevertheless, whosoever is arguing, since he is not having the benefit of the copy of the remand application of the department, so he would not know whether the department is going to seek police custody or remand custody, judicial custody. So the concerned lawyer should always seek that if the bail is not granted, then the court should remand the accused to a judicial custody. Now, let us have a look at the provisions of the GST Act, having gone through some of the basic elementary criminal jurisprudence. So first of all, it is the section 69, which says that if the commissioner has reasons to believe that a person has committed any offense specified in clause A, B, C, or D of subsection 1, which is punishable with an offense under clause 1, 2, or 1 or 2 of subsection 1 or subsection 2 of the he may by order authorize any person of central tax to arrest such a person. So it is only if the person has committed an offense under clause A, B, or C, or D of the subsection 1, then only the commissioner can authorize an officer to arrest such a person. Otherwise, the arrest is not required. Otherwise, you see, the prosecution will be launched subsequently, and then only once the person is convicted on offense, then one will be arrested. But if a commissioner has reason to believe that a person has committed offense under clause A, B, C, or D of subsection 1 of 132, which we will discuss just in a few minutes, then only the commissioner should authorize arrest. And section 69 subsection 2 says that in case a person is arrested under section 132 subsection 5 for cognizable and known bail of an offense, the officer so authorized causing arrest is required to comply with the following obligation: to inform the person arrested of his grounds of arrest and produce such person before a magistrate within 24 hours of such arrest. Now, the reason to believe is not the reason to suspect. So there must be some material before the concerned authority before seeking a remand of a particular officer. Now, the material should be an objective material, and it should not be merely a suspicion or a gossip or a rumor. Now, CBIC has also laid down detailed guidelines with respect to power to exercise arrest. And this also follows the same well-established jurisprudence in the matter of arrest. And it quotes a particular judgment of the Honorable Supreme Court, which says that we may note that the personal liberty is an important aspect of our constitutional mandate. The occasion to arrest an accused during investigation arises when the custodial interrogation becomes absolutely necessary, or it is a heinous crime, or where there is a possibility of influencing the witnesses or accused may abscond. Merely because an arrest can be made because it is lawful does not mandate that the arrest must be made. A distinction must be made between the existence of the power to arrest and the justification for exercise of it. If arrest is made routine, it can cause incalculable harm to the reputation and self-esteem of a person. If the investigating officer has no reason to believe that the accused will abscond or disobey someone, or is in fact throughout cooperated with the investigation, we fail to appreciate why should there be a compulsion of the officer to arrest the accused. Then it goes on to say that the reason to believe to arrive at a decision to place an alleged offender on arrest must be unambiguous and amply clear. The reason to believe must be based on credible material. So it is not that just because the arrest can be made, therefore it should be made. So as long as any accused is willing to participate and is not likely to flee, he should not be put behind the bars. Now, one more circular has been issued also by the CBIC with respect to launching of the prosecution under section 132. So it says that the standard of proof required in criminal prosecution is much higher than the adjudication proceeding. And one has to establish the case beyond the reasonable doubt. So even if the demand is concerned in the adjudication proceeding, the evidence should be so weighty that they are likely to result into conviction of an accused. So ordinarily, the prosecution should not be filed merely because the demand has been confirmed. So one has to exercise extreme caution for launching of the prosecution proceeding, and it should normally be launched only if the amount of tax evasion or misuse of ITC or fraudulently availing of refund is more than 5 crore rupees. Now, one important aspect which arises in the mind is, because it so happens that sometime once the prosecution is launched under section 132, or while the adjudication proceeding is going on, or suppose the adjudication process is completed also, but the matter is pending in appeal. So one seeks quashing of the prosecution proceeding on the ground that, look, the matter is a tax offense. As of now, whether the offense has been committed or not is a matter which is sub judice. So therefore, the proceeding should be quashed. But herein, I add a word of caution that it is an established jurisprudence that the prosecution proceeding and adjudication proceeding can be done simultaneously. So one should not seek quashing of that proceeding, but one can definitely seek a stay on the prosecution proceeding. There is a very recent judgment of the Bombay High Court which relies upon a Honorable Supreme Court judgment, which says that wherein the prosecution proceeding was launched or the so-called notice was issued in the purview of the Benami Property Act, but the court said that since the Black Money Act, but the court said that the matter is still being assessed by the IT authority, which is subject matter of appeal. So therefore, the criminal proceeding should be stayed. Similarly, the Honorable Supreme Court, in one of the matter, stayed the criminal proceeding. It did not quash it. It merely stayed, because it said that the fate of the criminal proceeding depends upon the conclusion of the civil proceeding, that is the assessment proceeding, and therefore till the time such a exercise is completed, the criminal proceeding can be stayed. Now, within the purview of the GST Act, the offenses are classified into, again, two categories as I discussed: cognizable and non-bailable, non-cognizable and bailable. And the offenses are cognizable and non-bailable if two conditions are satisfied. One is the offenses are committed in clause A, B, C, or D of subsection 1 of 132, and if the amount of the punishment is more than 5 years. Except this, all other offenses are non-cognizable and bailable. Now, what are these clause A, B, C, D of subsection 1 of 132? Point number 1 is, that is, A is supply of goods or services without issuance of invoice with the intention to evade tax. So the clandestine removal cases where the goods are sold without invoices, that is one type of offense. Secondly, the issue of offense or bill without supply of goods or service leading to wrongful availment or utilization of ITC or refund of tax. So fake invoice case, where the invoice is issued, but the underlying supply of goods and service is absent, and which results into wrongful availment or utilization of input tax credit or refund of tax. Third type of offense is availing ITC using such fake invoice, or there may also be a case where the ITC is availed without any invoice at all. A lot of refund frauds have happened wherein people have claimed refund on the basis of a non-existent ITC because they claimed ITC in GSTR 3B without there being any underlying invoices at all. So that is the fourth kind of offense. Then fourth kind of offense is where the tax collection is made but the same is not paid to the government within a period of 3 months from the due date of payment. So these are the 4 kinds of offenses wherein if the punishment is more than 5 years, then they are cognizable and non-bailable. Now let us look at the other type of offenses. Other type of offense is evasion of tax or fraudulently obtaining refund, then falsifying records or documents or books of accounts with intent to evade payment of tax. Now, the GST Act has been partially decriminalized by omitting some of the offenses. For example, obstructing or preventing any officer in discharge of his duties has been omitted by the Finance Act. Tampering or destroying any material evidence has been omitted, and failing to supply any information or false supplying information has been omitted. So these are the offenses which has been now deleted from section 132. Now, what is the quantum of the punishment? If the amount of tax evaded exceeds 5 crore, then the imprisonment is 5 years and fine. In case the tax evasion is more than 2 crore, but less than 5 crore, then punishment can be up to a period of 3 years. And in case of an offense of supplying of fake invoice, and if the tax evasion or the ITC exceeds 1 lakh but does not exceed 1 crore, then the imprisonment may be up for a period of up to 1 year. Now, in terms of section 132 subsection 2, if any of these offenses are committed and one is convicted second time, then irrespective of the quantum of the evasion of the tax, the imprisonment shall be up for a term which will extend to 5 years. Now 132(3) says that the minimum sentence, unless the adequate reasons are recorded by the court, the minimum sentence which should be given is 6 months. Now again, the power to arrest is subject to provision of CRPC, which includes section 49 and 41A of CRPC. And as I was saying, the Supreme Court judgment in the case of Arnesh Kumar versus the state of Bihar is a very, very important judgment, which says that section 41 and 41A applies where the offense is less than 7 years, then the arrest shall not be accused unless he is not responding to the summons. So as long as the offense is less than 7 years and one is willing to participate in the proceeding, the arrest should not be made. Now, the another issue, which is a very important issue to my mind, with respect to power to arrest in the first place, whatever may be the quantum of quantum of evasion or the quantum of punishment, even if the, let us say that the fraud falls within the purview of clause A, B, C or D of subsection 1 of 132, and the amount of tax evaded exceeds 5 crore. The question is, can such arrest be made when without the assessment taking place? So herein, there are some of the judgments which are decided either way. Here, one of the very important judgment, even though not in the context of GST, but in the context of service tax, where the provision was almost analogous, the Honorable Supreme Court upheld the judgment of Honorable Delhi High Court, wherein it was held that the power to arrest is to be used with great circumspection and not casually. And it cannot be without making an assessment by passing the procedure as set out in section 73A and 4 of the Finance Act. That is, before power to exercise arrest, the so-called notice should be issued and the assessment of tax should be completed. It cannot be done otherwise. That was the view of the Honorable Supreme Court in the context of service tax. Now, Honorable Madras High Court in this celebrated judgment of the Jayachandra Alloys versus Superintendent of GST, the Honorable Madras High Court said in the context of GST that section 132 said that it can be invoked only if an assessee commits an offense. So the commission of an offense, the use of the word committing of an offense makes it more than amply clear that the act of the committal offense is to be fixed first before punishment is offense. So in the view of the Honorable Madras High Court, no power to arrest can be exercised without doing the exercise of the process of adjudication and assessment. Now, Honorable Punjab and Haryana High Court, it laid down several guidelines before exercising the power to arrest. This was also a judgment in the context of GST. And here it was held that the power to arrest should be exercised in exceptional circumstances, which illustratively may be a person is involved in evasion of huge amount of tax and is having no permanent place of business. A person is not appearing in spite of reiterated summons, is not involved in huge and is involved in huge amount of tax. A person is a habitual offender and he has been prosecuted or convicted on an earlier occasion. He is likely to flee from country. He is originator of fake invoices, that is invoices without payment of tax. When direct, documentary or otherwise concrete evidence is available on file record of active involvement of person in tax evasion. Now, this particular judgment of Honorable Supreme Court, I am not discussing because now already there are two Supreme Court judgments which I have discussed that the condition of pre-deposit cannot be imposed for the purpose of granting of the bail. Now, there are contrary judgments also of the other high courts, where, for example, this particular judgment of Honorable Gujarat High Court in the case of Vimal Yashwantagiri Goswami versus State of Gujarat, it says that the arrest can be made if the commissioner has reason to believe that the offences are specified offences under section 132 are committed and no assessment yet has been made. So it said that the power to exercise arrest can be exercised on the reasonable belief of the commissioner even without prior adjudication of the tax. Now, Telangana High Court in PV Ramana Reddy also decided on the similar lines that it is not necessary that assessment has to be made. It said that the assessment can be made even without completion of the assessment. And herein, it is important to point out that the SLP against this Honorable Telangana High Court judgment was dismissed. But let me tell you that since the SLP was dismissed without commenting on the merit of the Honorable Telangana High Court judgment, so it cannot be said that the judgment of Honorable Telangana High Court has merged merged with the uh, judgment of the Honorable Supreme Court. So it is not that the Telangana High Court judgment, just by virtue of the dismissal of the SLP, can be said to be the judgment of the Honorable Supreme Court, because Honorable Supreme Court dismissed the SLP at the threshold. Since it was dismissed at the threshold without entering into the merits of the case, so it cannot be said to be a judgment of the Honorable Supreme Court. Now, Rajasthan High Court also in one of the judgment held that the assessment or determination of tax is not a prerequisite before exercising the power to arrest. Now, another important question which comes to the mind is that suppose fake invoice is issued or some tampering with the evidence is done. Now, all of this can be an offense under the purview of Indian Penal Code also. So the question is, while a proceeding is initiated within the purview of the GST Act, whether a simultaneous FIR also can be lodged under Indian Penal Code. The answer is yes. And this has been answered by the Honorable Allahabad High Court in the case of Govind Enterprises, because it was held that there is nothing in the GST Act which overrides or expressly or impliedly repeals the provision of the Penal Code or bars lodging of FIR under IPC. Because if an offense is an offense both under the GST and the IPC, then the department is well within its right to launch the proceeding under the provision of Indian Penal Code also. Now, another important aspect which I think needs discussion is whether an investigating officer can be called a police officer. The reason I wish to this particular aspect is that the section 25 of the Indian Evidence Act says that the confession made before a police officer is not an admissible evidence. So the question is that many a times a confessional statement is extracted by the officer from a SSE. So the question is whether it can be used against the concerned SSE. So the Honorable Supreme Court, in the context of customs law, had decided that the revenue officer is not a police officer, and therefore a statement made before a customs officer is a admissible offense. Now, another question which comes to mind is whether the Evidence Act, just give me a moment, please. Yes, thanks for your patience. Now, one of the important aspect is whether the Evidence Act does apply to the tax laws. So herein, I think one important judgment of the Honorable Income Tax Act, it says that even though the rigors of rule of evidence contained in Evidence Act does not apply to the taxation laws, but it imposes a salutary principle of common law jurisprudence which could be attracted to a set of circumstance that satisfies condition. So I think it is very important for us to have a knowledge of the Evidence Act, and depending on the fact and circumstance, we do apply to a particular case and take the help of it. Now, another question which I was already discussing is that whether the confessional statement recorded is an admissible of evidence. So there are judgment which says that the confessional statement recorded is admissible evidence, but here I wish to point out that even if it is admissible, there is nothing which prevents a particular assessee to retract from a statement saying that it was not voluntary and it was given because of the threat of arrest and various other mental and physical torture either caused or threat of such physical torture. So the question is, how does one establish whether the statement was a voluntary one or a made under a threatening circumstance? So herein one very important judgment of the Honorable Supreme Court comes to my mind, which is in this particular slide. It says that it is not necessary to prove to the hilt that the confession had been obtained by way of inducement, threat, or promise. The burden is also in the prosecution to show that the confession is voluntary and not obtained as a nature of as an outcome of threat, if the same is to be relied upon solely for the purpose of sex. So if that is the sole evidence for securing conviction, then it is not going to help the department. They have to necessarily find out other evidences also to convict a particular accused. Now, the evidentiary value of the co-accused is also admissible in evidence in terms of Section 30 of the Evidence Act, if the two accused are tried together. But the question of relying upon the value of the statement of a third party, the courts have consistently taken a view that unless the benefit of cross-examination is given, the statement of a third party has no evidentiary value. So my advice is that as soon as any statement is relied upon by the GST department, the SSC should immediately seek cross-examination so that later on, if the department does not allow that benefit, then that can be the ground itself or the only ground on which one can seek quashing of the entire proceeding. Now, the another, you see, important aspect which I think needs discussion is whether either the adjudication proceeding finding is binding on a prosecution proceeding or vice versa. The answer is that adjudication proceeding is not binding for launching of a criminal proceeding. And even if one adjudication is done, since the standard of proof in a criminal case is much higher and it should go beyond reasonable doubt, so the department has to have additional material to convict a person within the purview of Section 132. Now, some of the judgments of the Honorable Supreme Court which I would like to discuss is that in very recent judgment of the Honorable Bombay High Court, the Honorable Bombay High Court observed while granting bail that the maximum sentence that can be imposed upon conviction for committing an offense under section 132 1B and C is 5 years. In Ernest Kumar, Supreme Court had held that in case of an offense where the punishment upon conviction is 5 years, if a person complies with a notice under section 41A of the CRPC. Now, section 41A says what it says, that one has to be summoned if the offense is punishable with less than 7 years. So in the context of the GST, since the offense is only maximum punishment is 5 years, so the power should summon under section 70 is there. So once that is exercised and the petitioner is cooperating and repeatedly appearing before the concerned authorities, then Honorable Bombay High Court said that if the party is participating in the investigation, then the arrest should not be made. So I think this is a very important judgment, because many a times it so happens that even if the concerned assessee is regularly appearing before the authorities, they have a tendency to arrest in order to secure and force the assessee to make payment of the tax even before the adjudication proceeding has commenced. So that is the reason that the courts comes down heavily on the department in such cases, that if you are regularly participating, then what is the need of arrest? Now, here in one particular judgment of the Honorable Karnataka High Court, Honorable Karnataka High Court granted anticipatory bail on the same ground that releasing the petitioner on the anticipatory bail is fair, because it is not that he cannot be secured for the purpose of investigation or he is likely to flee. And the maximum offense which can be given under the purview of the GST Act is 5 years. So therefore the bail was granted. Now, another important aspect in the GST, which is a departure from the normal criminal jurisprudence, is that under the general criminal jurisprudence, the onus is on the police officer to establish that the accused had a guilty mind. But in the GST, if the offense which are falling within the purview of section 132, then there is a presumption of such mental state or the guilty mind. So section 135 is a departure from general criminal jurisprudence. Now, with respect to the relevancy of the statement given before the officer for the purpose of prosecution under section 132, it talks about the value of the evidentiary value of the statement of a third party. It says that generally, unless the person is dead, whose statement is taken, or it is impossible to seek his cross-examination, the value of such a statement is 0 unless the cross-examination is done. Now, with respect to the offenses of the company, there is a judgment of the Honorable Supreme Court says that while the company is a natural person, So while the company may not be possible to be put behind bars, but it does not mean that the prosecution cannot be launched against a company, because even if the company cannot be put behind the bars, but the officers of the company who are responsible for such company officers, they can be put behind the bars, even though they have to be independently prosecuted for their offense. But if the company is also simultaneously prosecuted, there is nothing wrong with it, because the company may not face the sentencing part of it, but it can be subjected to fine within the purview of the criminal law. Now, the last thing which I would like to discuss is the compounding an offense. So under the GST law, whatever may be the offense, one is entitled to compound the offense by making payment of the compounding fees under section 130 of the Act, which can be minimum of 10,000 amount or 50% of the amount of tax, whichever is greater. So if that is done, the compounding is done, then there will not be, the person cannot be put behind the bars, and he has to be absorbed from the criminal aspect of it. So with this, I conclude my today's talk. Now I will take up some of the questions. Mr. Lakshmi Narayan has asked that is the stated final order confirming the adjudicating authority of classification of a product by erstwhile Excise Department under the holds good in the GST era, kindly confirm. You see, the stated final order confirming the adjudicating authority order of classification of product may or may not hold good depending on the facts of the case. Suppose in the GST era, the new tariff heading has come, because the GST is not strictly following the HSN system of classification. So if a new heading has come, and if such a benefit of such a heading can be taken and it is advantageous to the SSE, then one can take advantage of that depending on the facts and circumstance of a case. Now another query is, it's a longest one, that Mr. X, a registered dealer of West Bengal, claimed ITC in GSTR 3B, also filed 9 and 9C, which included IGST, for which the supplier had wrongly shown the place of supply as consignee's address instead of buyer's address. Assistant Commissioner of uploaded ASMT, for which he replied by GSMT 11 along with a scanned copy of the invoices, wherein buyer's address was in West Bengal, but the consignee address was outside West Bengal. But the SCR is not given interrogated for the same address in GSTR 1. The Assistant Commissioner have uploaded GST part of intimation of liability, wherein full GST amount of such case has been demanded. What is the solution for whether X should apply for time extension to reply? Is the payment of tax and interest on whether there is a merit in the case when I can get relief from the appellate authority? Certainly, you see the GSTR 1A is a stage prior to the so-cause notice. It is a pre-so-cause stage. So no harm done as of now. If they have not, if you have not replied as yet, then you can reply subsequently on receiving of the so-cause notice under GSTR 1. And you can also file an extension for filing a reply under GSTR 1A also. Whether or not the authority grants you the adjournment, it does not affect your case at all, because you can respond at the stage of the so-cause notice. And in my view, this is a case of a procedural error, and it is an established jurisprudence that the substantive right cannot be denied for procedural infraction. So your right to input tax credit, provided all other conditions are satisfied, they cannot be denied to you just because there is an error on part of your supplier to upload the GSTR1 while filing is written. So I don't think the demand of the department will survive at all in this particular facts and circumstances of this particular case. Is there any other query? Please share my presentation with all the participants. Some are complaining that they don't receive it. Madam, please share my PPTs with everyone because I have shared all of them with you.
Yeah, sure, sir. We have already shared to everyone who registered through the Google form. We have shared through mail. If there is any query regarding the recordings and the PPT, I'm giving my number here in the chat box. You can contact me in this number.
Okay. Thank you. Please. And today's PPT also I will share immediately as soon as we end this session, and then you please share it with the participant immediately.
Yeah, sure, sir. I have shared my number in the chat box. Please note it down, and you can contact me. Then I will share the PPT and the recordings.
Right. So next session, let us do on 6th of May, because 29th I have some other preoccupation. So next session we can do on 6th of May. And with respect to that economic offense seminar which I discussed with you, please give me a couple of more days to chart the itinerary. And
sure,
then we can discuss the dates also, because earlier I had given you 6th of May.
Yes.
But that may not be possible. So sometime during the end of the May probably we'll plan.
Yes, sir. We can discuss and fix it later.
Yeah, and I will give you the itinerary for that in a few days. Now there are some more questions. I mean, let us take it and then we can close this particular session. Mr. Joman Varghese is asking, under section 122(2), the penalty for non-filing GSTR 3B is 10% tax due or rupees 10,000, whichever is higher, whether without passing order under section 62 impose penalty. Not at all. For imposition of penalty, it is mandatory to issue a show cause notice. There cannot be any direct penalty. And if such a penalty is levied, then you are very much entitled to get it quashed from the High Court directly. Okay, so we can close today's session. I think there is no more question. Thank you very much, everybody.
Yeah, we can wind up the session, sir. Thank you so much. Vinay, sir, thank you, everyone.
Thank you. Thank you very much.